I wouldn't say that's exactly true.
Have you always been a talker, Gene? As a kid?
What's that?
When you were a kid, did you talk a lot as a kid?
No. I was quiet. I was quiet in high school. I wasn't the first to always raise my hand and want to say something or anything else. I was sort of laid back, somewhat reserved. I never was a outward, forward kind of personality.
Right.
But,
Hey, Cracker Jack, how's it going, man?
Hey, all right.
All right.
How you guys doing?
Cracker Jack just joined us, Gene.
all right.
Mike's
Cracker Jack is there.
Yeah.
Hey.
You got a surprise in the Cracker Jack box.
Yeah.
He always got one for us.
They're just doing their dinner thing, and Gene was waxing poetic there.
Okay.
Oh, cheap shit.
Yeah, thanks for the info.
Public, man. Public brand is good.
Yes.
Yeah. No problem there.
Yeah.
That guy isn't on your side
Ozzy. Yeah.
at all. He's a douchebag.
I mean, maybe he's in over his head or something. I don't know, but yeah, he seems just stressed and yeah. When I went to the courthouse in the parking lot, I was getting ready to get out and go up to the courthouse, and he was late getting out of his car, and then he ran. He had to run into the court. So I don't know if he's. Oh, I got you muted, Mike. There was noise. But yeah, he's. I don't think he's the greatest.
No, I mean, he could do something, but that's not his intention at all. He just wants you to just sit there and take whatever they want to shove in your face.
Isn't that what public defenders do? I mean, from what I've heard, they're there.
Yeah.
To keep the wheels going.
That's what they do. I mean, you can encourage them and challenge them to do otherwise.
Which
I mean,
I will.
Yeah, just like simply ask him. He's from some of the things. I should have written some more stuff down. I just like listened to it just quickly.
Yeah.
But the most basic thing was your presumption of innocence. From everything he was saying, it looked like he had no inclination towards that at all.
No.
He wants you to either pay a fine, do the deferment thing, which he's not really making it clear, although it may be it's not going to be dismissed. They're just going to not hold their allegation against you. It's still going to be on your record, because then that will be a consideration. If something were to happen again, they'll say, oh, well, you had this particular incident and there was a deferment of some sort of agreement that was provided to you before, so you're not eligible for that again.
He did say at one point, I mean, clear, but he said, that after this is over, you can try to get it expunged or something.
You can what?
Try to get it expunged, completely expunged.
Gosh, that's hard to do.
Right.
From hard to do to nearly probably impossible.
Now, the thing is, in Florida, it's not hard to do, but you have to go through all the rigmarole, jumping through the hoops, bullshit. Get a court hearing, go before a judge, ask for it to get, present your case, get it expunged. And you can only do it one time in the state of Florida.
Mm-hmm.
You can only expunge one charge. If you've been charged with 5 crimes, you can only expunge 1.
Wow. Huh. Yeah. So I think your notice to dismiss, I mean, that's the first step, it seems like.
Yeah, that's the first step. And also asking for discovery and Brady material, because those are all factors that should prove or provide for the prosecution's what the legal term called standing in the case. If they don't have any of those elements to show proof of a valid cause of action, that's another thing, which is all the different reasons that they have to justify bringing this case to court. There shouldn't even be a question of, oh, let's wait to see what they're going to do if they've already filed an affidavit or filed the case in court. He should have been like, if they don't file something in court, we're going to seek to get this dismissed.
Yeah, that's what it seems like. What's the Brady thing? You mentioned that a few times.
The Brady is all the information that would prove your innocence. Which, for example, let's take the example, like a criminal case, for example, right? If there was a witness that said they saw you at Walmart, for example, at the same time, this is a bad example, at the same time that those people said that you allegedly trespassed at their store, and then the prosecution decided to withhold that particular witness from you, that's a violation of Brady. That's grounds to have the case dismissed. So for example, more specific to this case, if they didn't give you a clear determination or clear and concise information that you were actually allegedly trespassed, and they know that to be true, but they're withholding that information from you, that's a violation of Brady. It comes from, I think it was signed into law during the Clinton era, when I think it was related to a child or something like that. I don't recall. And there was a particular detail that could have gotten the guy off, or would have shown him not to be guilty. Right. And then the people who were trying the case, the prosecution, the state, or whoever, decided not to bring it to the defendant's attorneys. Okay. And so they signed that into law to prevent that from happening.
Okay.
And then did you read over the Brady and discovery are essentially the same thing. And so that's like questioning, getting the information about all the cops who were there, what statute they said that you actually, broke, which from the affidavit that the prosecution submitted, that's a little bit part of Brady. And all the other witnesses, like in some of those police reports and such, they just put witness and all of that stuff. You need statements from all of those people making those allegations, but they're going to try to say, oh, that's all for trial. That's proven their case in trial. I mean, no, it's not.
I should be able to see all that.
Yeah, you should be able to see all the witnesses, any claimed witness who's against you. It's sort of similar to when you hear of these big cases, right? And you hear of what pre-trial and what is the legal term that they use for it?
I don't know.
When they question all the people who are before trial.
Deposition?
Deposition. Sort of like that. They question them all before trial.
Right.
And they call those pre-trial hearings and stuff like that. Before, and then they ask them the same questions again at trial. But these guys just conveniently try to leave all that stuff out, so you can just get ushered into the
Right.
system. And then once you, keep silent and you just unknowingly relinquish those rights, they're kind of hard to get back.
Yeah, let me interject. This is a profound point that Cracker Jack's bringing up, because it kind of goes to our whole initial idea about, see, Brian Cracker Jack was thinking early on, we were both thinking, we got to get this whole virus thing in the court. So Brian kind of was even thinking, he didn't want to get arrested. But he was kind of open to the idea of getting arrested because it was an opportunity to get it in court so that we could challenge the virus itself, right? And people have criticized us like, you're going to get laughed out of court. It's a freaking, trespass case. You're not going to, turn it into, something else. But actually, the great point that Cracker Jack's bringing up is if you go to trial, you have the right, like he's saying, to depositions. And that means the attorney, you can demand for him to have that woman come over, right? And you're allowed to be there. And we can have the questions for him to ask her, right? So in all great questions we can come up with in terms of, is she aware it's a place of public accommodation? What are their policies on public accommodation? Do they follow federal law? It's so beautiful. The reality is, did you have reason to believe he was a danger? Why do you have reason to believe he's a danger? Do you know there's a virus? You know what I mean? It does open the door to get into even to being able to question the virus because of the depositions, because you could ask anything you want of these witnesses. So that is the beautiful aspect of it. The depositions.
And who decides on all that? What questions are asked and all that?
You do, bro. Even if you have a public, in fact, on the one hand, we're saying it's not good for you to have a public defender, right? It's good to go pro se.
Right.
On the other hand, it is good to have a public defender if you're telling them what to do, right?
I should be
and
able
if we've got, legal minds like Cracker Jack in the background and Steve in the background, and they're giving us ideas, and we're making this freaking public defender do his fucking duty, right? And then on top of that, we're demanding depositions, right? And on top of that, we're giving him the questions I want you to ask. And if he doesn't, then he's a derelict of his responsibilities. And we say we file complaints against him and say our public defender's not doing his job. We want another one, right? So you start, now instead of you being the basketball that they're dribbling around, they become the basketball that you're dribbling around. You could really, if you have a winning case, which you do, and we do have an ulterior motive on what we want to try to, get questioned under depositions, right? Then you're playing the system. They're not playing you anymore. You're playing them.
Did you see the part, Cracker Jack? I don't know if I'm pretty sure I recorded it, but at one point he said, we were talking about something, and he said, like I said, I know I'm not guilty. And he said something like, do you know how many people that have come through here that have said that they're not guilty? And
that is so typical, bro. That's typical with attorneys, and it's typical even more so in jail. When you're in jail, you're guilty.
Yeah. And that's where that was, I didn't see that part, because I meant to watch the whole thing later and just like, take notes just to critique the thing and send it to you, because that's where you should have been like, okay, as my attorney, what is your position on this? Do you think are you thinking I'm guilty or not? Because if you think I'm guilty, and if you don't believe me, then you're not for me. Then you need to recuse yourself from this particular case.
Right.
Because it looks like right now, it was upsetting. Right now, you're trying to like bury me.
Exactly. That's what
right.
That's the impression that I got.
And that freaking secretary, whatever the heck she was,
really?
Trying to say that, I forgot what she was trying to say, but that it's just for arraignment. It's you're not going to go there to do anything else. The arraignment's the most important aspect, one of the most important aspects of any particular case, because that's where you make the determination. You have either accept that you're liable, you're responsible for the particular allegations that they're making against you, and you're willing to be ruled by their rules, or you're not. And right now, they're not showing that, because there is.
I'm actually looking forward to the next. Initially I was thinking I had to be there with Brian right on the first trial, but then it's time when I was realizing, wait a minute, I'm quite sure I'm not even gonna have to be there, because that's what it's going to be. It's going to be bullshit. They're either going to dismiss the case on day one when you go there, or it's just going to be a plea guilty or not guilty, right? But since you kind of broke through the ice and you got the shit going now, I'm going to be there, man, on that next hearing. I'm going to be there, and we're gonna break the bank on the motherfuckers with the law in our hand about we got the right to go in this place of public accommodation.
So what do you think about me even being able to talk to the judge, because they're pushing that administrative ordinance that supersedes a world.
It doesn't supersede federal law, brother.
It doesn't supersede anything, but they've got the guns and they've got the people.
Exactly.
And they've got the weapons.
Saying-
That's the only thing. And
you got to watch the video if you haven't seen it already, Cracker Jack. I really need to make an edited version of when we went to the public building in Miami. Brian and I went to see the mayor's office, and we had to get through security. The head of security for that entire building came down. He was on the phone doing circles for 20 minutes, trying to figure out how to deal with us, because we were not wearing masks and we were not going to go wear masks. And we are going up to the mayor's office because we got the right. It's a public building. We held our ground and we went up there.
Yeah.
Wow, that's good.
Yeah, I mean, it would definitely be a big shindig. They don't.
If a person says the right words and they're persistent, anything's possible.
That's what it is,
Just like that.
Yeah, it's you nailed it, man.
And then the other thing, Ozzy, doing his best for me. He says, if you're not going to wear a mask, they may come out and handcuff you, and take you to jail. And I'm there. I'm there at the arraignment. And why would he even?
Right.
Yeah, because he's an idiot, and that's where a person should have said, "Are you not my attorney to try to? You see the so-called governor's order, and you're claiming to be under this particular law. Why don't you uphold that and represent me as my attorney?"
Well, the beautiful thing too that just hit me, Brian. Sorry for interrupting you, Cracker Jack, but the governor just Friday, right?
Well, yeah, what did he do? What did he do?
What he did was he essentially said that you can't be fined for any mask wearing. If
you can't be fined, then you can't be dicked with, period.
You don't have to wear a mask. But
I can't be fined, but I can be arrested? Bullshit.
That's what they're going to say, yeah.
Yeah, but we're got to have the most up-to-date order. We're going to have it all highlighted. We're going to have we're going to have all the law, man. 42 USC. We're going to have the Americans with Disabilities Act. We're going to have everything highlighted. We're going to be ready to go.
Let me ask you this. So a public defender works for the state.
A public defender, is hired by the state to work for their clients. Whoever the state refers, according to the Constitution's right to assistance of counsel.
Right.
But they're paid by the state, and these guys are all buddy with the prosecution, with the judge, because they want to get ahead and
right,
maybe get jobs later or whatever. So
or something.
Yeah, they don't care anything about the people that they're seeking to represent. And this guy completely shows that, trying to tell you, oh, you can, if you just accept this, you'll pay $30 here, $30 there, and within a few months you'll be free from it.
Within
you'll
be fine.
Yeah, it's all a lie. What what I would do, because the only good thing with having him, unless like what you guys said you did with the mayor's office, continue to press the issue to be able to get in there. The only good thing about having him that day was that if you didn't go into court that day, they would have put a warrant out for your arrest for not being there, although they denied you entry. That's
mean
what they would have done.
If I hadn't showed up on the courthouse steps, they would have sent out a warrant.
No, if you had not been inside of court, because as your attorney, he was there in your place.
Right.
So that was the only good thing about having him there.
Right.
But
Oh.
he was a terrible.
You're saying if I had gone there pro se or whatever you call it, and they wanted me to wear a mask and I wouldn't, you're saying that they would have issued a warrant?
Yeah.
Yeah, they just said it was you were a no-show. They'd have called you a
Yeah,
no-show.
they would have failure to appear. That's
Uh,
what they would have done.
That would have been good. I mean, I wouldn't have minded that. Then they would have really, I would have really got them in the end on that one.
Yeah, and they don't care. They break their own rules.
Right.
So what I would do is to see where this guy really stands. If he's going to have the presumption of innocence for you, to see if he's even credible to try this case for, or to take this case for you, is ask him those questions. Like, really, are you presuming me innocent here? Because if you're not, as my attorney, then we don't need to talk. You just need to go and recuse yourself from this particular case.
Exactly.
Because it's baffling too that he was like, oh, if you plead guilty and all of this stuff, then you're responsible for court costs and you're responsible for the public defender fee and all of that. So in turn, they're still stealing money from you.
Right.
And it's not right. But yeah, I wouldn't wait until whatever, like he says, until the next arraignment, because you need to find out where he is. They're saying, one thing that lady said was, after the trial, after the arraignment, then we'll have more time for you.
Right.
What kind of buffoonery is that?
You know what we're going to do, Brian? We're going to contact the sheriff's office.
Well, speaking of sheriff, I was just going to mention that. Yeah,
We're going to contact the sheriff's office. I'm going to help you write a good email, and we're going to let them know we have a court hearing. It's your responsibility to uphold federal law. Under federal law, we have a right to enter that public building without a face mask.
That's a good idea.
It is buffoonery, Crackerjack. But I was going to say, in relation to that, I wasn't recording. I screwed up, but I went to the big fat sheriff standing at the door, and I said, I don't wear them for health reasons. And he said, you got to wear a mask. Got to take your temperature. And I had the law there, the ordinance and the ADA. And I said, it says right here in the ordinance that if I have a disability, I don't have to wear a mask. He said, it doesn't matter. You got to wear a mask. And then I said, where's your supervisor? He said, it's not going to make any difference. And I said, I want to talk to your supervisor. And he was standing inside the courthouse. And he said, hey, this guy, trouble. This guy's trouble. And the guy said, what is it? I said, the ordinance right here says that I don't have to wear a mask. He said, it doesn't matter. You got to wear a mask. And they're sheriffs, the fat sheriff, and then the supervisor inside. And
that's why we're going to get in touch with the sheriff's office in advance, and we're going to put a federal threat on his ass if he doesn't agree to be there to assist us.
Well, as a precursor, either tomorrow or the next day, I'm going to the Up store in Fort Pierce and I'm going to call a sheriff and have them meet me out there and show them everything and just record everything and see what they, if they do the same shit.
Right.
Damn,
I got to be there with you, man.
They only trespassed you at that particular location, right?
That's what it says. You have trespass of a structure and that particular structure. So even though I guess it has another location, I guess it only applies to the one. I mean, I haven't heard anything different. So.
Right.
Okay. So all the information that you got, like the affidavit that the prosecution sent and stuff, did the public defender have all that? that day, or was that all provided afterwards?
I think he, let me think, the one I'm gonna be looking at right here in just a second is the trespass prosecution from the state. That one is, I mean, he had to have had it because it came in, yeah, before that, September 17th.
We also need to put the judge on notice in advance that you have a court date and you plan on being there and you do not wear a face mask. We're going to contact the sheriff's department and the judge. I'm going to write the letters. In the morning when I get up early, it'll all come to me.
That's a good idea to send it to the
Now that I
judge.
know what I need to write, it'll all come to me when I wake up tomorrow morning. I'll
So-
turn on my phone and start speaking it into Facebook.
So Cracker Jack, yeah, this is, I think I sent it to you, but yeah, it's kind of like gobbledygook. The state of Florida case number, trespass in structure on or about August 19th. Brian Root did willfully, without being authorized, licensed or invited to enter or remain in a structure, the property of Up Center as owner or custodian, or having been authorized, licensed or invited to enter or remain in the said property, willfully refused to depart after having been warned by the owner or lessee of the premises or a person authorized by the owner or lessee to depart in violation of Florida Statute 810, which is not true. On the 19th, we did not refuse to leave. We did not refuse to depart.
And one of the things that what was unclear to me with that particular piece of paper, they put the statute code and they put the 2A beside it. As your attorney, he should be able to give you a clear understanding of what that 2A means. Maybe the prosecution is trying to play some sort of trick.
You mean the trespass in structure in parentheses M2? Or where's the 2A you're talking about?
Wow, what happened?
Well, I don't know. Did you get knocked out?
Yeah, I got knocked out.
Oh, sorry. Yeah, I don't see the 2A you were talking about. I see a M2 next to trespass in structure. But I guess that just means misdemeanor probably or something. I don't know. But where was the 2A?
It's after, maybe it wasn't on the affidavit that the prosecution submitted. Let me try to look at it here again.
Okay. Yeah, it could be on one of these other arrest report or something.
Yeah, but the attorney needs to explain all of that. Like,
He doesn't have time.
if he doesn't have time, then he needs to, recuse himself. If he's saying he doesn't have time until you agree to be tried by the charges, that's just a lie.
Yeah.
I mean, there's no other way to say it. And then people sit there and they accept that stuff all day, so these guys can get ushered in and complete these cases and make the prosecution look good.
It's just like a doctor, right? Where people just say, "Oh, okay, yeah, you know what you're talking about. I'll go along with it, I guess." Okay.
Yeah.
Oh, here I see it now. It's on your arrest report or something, whatever it's called.
Mhm.
It's got 810-08-2A. 810-.08-2A, trespassing structure or conveyance charges. So yeah, it does say it on the whatever I put Brian
Yeah.
court details.
Like, to me, what does that mean? It's unclear what that means just itself.
Yeah, because from the prosecution, it doesn't say anything about a 2A.
Mm-hmm.
So I don't know.
What does it call it?
Florida
Florida
statute
statute
810.08.
810.
I can send it to you. I got this.
810 dot what?
08.
810.082A.
Well, yeah, that's added in parentheses after it.
Yeah, well, it's saying whoever without being authorized. So that he was just putting what was written. He was referencing the statute. He wrote, Whoever without being authorized, licensed, or invited willfully enters or remains in any structure or conveyance, or having been authorized, licensed, or invited, is warned by the owner or lessee of the premises or by a person authorized by the premises to depart and refuses to do so, commits. So that was
Trespass.
just something they added, Florida statute.
But
2A, except as otherwise provided in this subsection, trespass in a structure or conveyance is a misdemeanor of the second degree, punishable as provided in 775.802 or 775.083. Penalties applicable of sentencing structure, mandatory minimum sentence for certain releases.
Maybe that means second degree.
Yeah.
and a misdemeanor. Where did I hear something about that? Oh, it was a stupid cop that made that presumption on a video I watched. A misdemeanor is usually not an arrestable offense because it's just a fine.
Yeah.
They can just cite you and give you a notice to appear in court and go on your way. But the cops want to make any sort of record for themselves. But the whole thing about that 2A thing, even if that cop, because he doesn't know any better, is only denoted that particular 2A section, the whole statute, that whole statute has to all include everything, especially number 3, which has to mean that that person was a threat to public safety or welfare.
Right.
So that's like a question that I would ask the attorney. Okay, they're saying that I'm guilty of this. What evidence do they have to show that, okay, I'm really liable for anything because I was a threat to public safety or welfare? Now, he may say that's an argument to be brought up at trial.
This is interesting too that they put 2A because it says 2A, except as otherwise provided in the subsection, trespass in a structure or conveyance is a misdemeanor of the second degree, punishable as provided by 2B, if there is a human being in the structure, which of course there were, it was a store with people in it. If there is a human being in the structure or conveyance at the time the offender trespassed, attempted to trespass, or was in the structure or conveyance, the trespass in a structure or conveyance is a misdemeanor of the first degree, punishable as provided by 775.082.
Wait a minute. So, but there was a person in the building.
Right. So they gave you the lesser of the charges, a second degree misdemeanor, as opposed to a first degree.
Okay, I see what the cop was trying to do. But it still doesn't, they still have to make sure that that number 3 was an element of the so-called trespass.
You mean, as used in this section, the term person authorized
Mm-hmm.
means any owner or lessee or his or her agent or any lawful officer whose department has received written authorization from the owner or lessee or his agent to communicate in order to depart the property. Case, which actually they don't, because that violates federal 42 USC code that says that no person, no owner, no manager, no person can, discriminate against you.
Yeah.
So first degree is worse than second degree, I guess, like a burn. Or no,
Yeah.
second degree is
Yeah.
worse.
First degree is worse.
First degree is worse. Okay.
Yeah.
So why wouldn't he give me that if there was a human being in the structure?
Because he's a dumb cop. Because it's impossible. I guess maybe they're instructed for businesses, because a business, there's usually going to be someone in there. write it under 2A as a misdemeanor.
It almost seems like if you go into somewhere where nobody is, that would be more egregious because you're thinking about stealing something or something. I don't
No,
know.
more egregious. If somebody's there, you could be causing harm to somebody. You
Yeah.
know, they don't know if you're a psychopath. And see, that goes to show the spirit of this law. That goes to show the essence and the true meaning of what this law is. Why is it more harmful if somebody's in there? Because you might be a psychopath that's trespassing and trying to break and enter and do harm to somebody, right? So it just goes to show that the purpose of it is to prevent ill will. The spirit and purpose and meaning of the law is to prevent ill will. Did you have any ill will trying to shop for food? No.
I wonder why the TAW, how does the TAW fit into this? Which that's your first time you get the TAW, and then the second time you get arrested, but none of that's mentioned in this.
What? Yeah, the TAW. What was it that they meant by that?
Probably trespassed as warning.
Uh,
Trespass a warning.
Let me see. He told me what it was at one
Trespass warning.
point.
Because the first time it was a warning. And the second time they say it was, you had already been warned and you came back.
Well, they don't. Trespass history.
Hmm. I'm trying to look for it.
I'm looking here. It actually pulls up Indian River County's code, 10 dash codes and signals. Find it here.
What's really weird is the statute says as provided in 775-082. And when you click on 775-082, it's talking about capital murder. What the fuck?
Trespass, arrest, warning.
Okay.
So I guess to be arrested, you have to get the warning first.
Yeah.
For a misdemeanor of the second degree by definite term. Yeah. Yeah, misdemeanor of first degree by definite term of imprisonment not exceeding 1 year. Misdemeanor of a second degree by definite term of imprisonment not exceeding 60 days. But then right underneath it, it says any person who has been convicted of a non-criminal violation may not be sentenced to a term of imprisonment, nor to any other punishment more severe than a fine, forfeiture, or other civil penalty, except as provided in Chapter 316 or by ordinance of any city or county. Any person who has been convicted of a non-criminal violation. Is that considered a criminal violation, trespass?
Yeah, I think they would call it criminal. Well, I don't know because they're
but here's another interesting thing. They put this under statutes of crimes, Chapter 810, burglary and trespass. Putting them in the same terms just goes again to show the spirit of the law. That law is about malintent, What a bunch of assholes. They're just using trespass. It's like a convenient little excuse for them just to use it to fuck with people.
Yeah. That's what it is. When's the next time you talk to the public defender? I want to say buffoon, but that's not nice. Do you talk? Are you supposed to talk to him any time before the next court date?
Well, I was hoping to talk to him Friday or whenever I had called him, and he got, flustered and said just, I got to go or something. And he said, we'll try to touch back next week.
Well, we got to get in touch with the sheriff tomorrow and the judge's office.
I mean, I'm sure I can call him and get to talk to him if I need to. But again, I was waiting on Rick Martin to send me something. So I'm going to call Rick Martin, the lawyer, tomorrow and see if he has any thoughts.
Was that the guy who's been in the calls sometimes?
No, this is a Rick Martin, the lawyer, has the constitutional law group, I think in maybe Naples or something, but he supposedly does everything for free. It's just by donation. And I had, I sent a letter off his website to talk to him, and then I called him and he said,
hey, here's something I just found. Preemption is the use of state law to nullify a municipal ordinance or authority. State preemption can span many policy areas, including environmental regulation, firearm use, and labor laws. States can preempt cities from legislating on particular issues, either by statute or constitutional law. So preemption, just something to remember. Preemption is the use of state law to nullify municipal ordinance.
But even the municipal, well, so maybe the administrative ordinance is a municipal ordinance, which is different than a county ordinance. I don't know. But I talked to Rick Martin and he said to fill out his affidavit thing on his website. And I did, and I sent it into him, and he said he would look at it and tweak it and get back to me. So
the law that applies to situations where state and federal laws disagree is called the Supremacy Clause, which is part of Article 6 of the Constitution. Basically, if a federal and state law contradict, then when you're in the state, you can follow the state law, but the feds can decide to stop you. Hey, boo-boo, Supremacy Clause. Supremacy Clause establishes that the Constitution, federal laws made pursuant to it, and treaties made under its authority constitute the supreme law of the land and thus take priority over any conflicting state laws. And the one I was reading before that indicated state laws override municipal laws. So municipal laws can be overridden by state can be overridden by federal.
So I asked about the speedy trial. I think you probably heard that where she kind of freaked out. Well, that's the first time we've heard about the speedy trial. Is that what you want? And I don't know if I want it. I guess I do. I don't even know what it means. But I think you would mention me to say that, right? Cracker Jack? Or?
I
like that.
They know exactly what it means.
I like my new legal term, preempt.
What does it mean? Speedy trial versus a regular trial, I guess.
Oh, a speedy trial means that they have to bring everything to court within 6 months. Everything needs to be finished by then. That means that you should have already been arraigned and you should be set for trial by 6 months.
Right.
That's what that means. If it's not, and that's 180 days from the date that they filed the charges. And if not, then they need to dismiss it for a lack of a speedy trial. And they know that. That's why it was very important that when he said that there was a continuance on the arraignment, it wasn't a continuance that was requested by him. It was something that was imposed upon him or done by the judge or that the prosecution requested. And he should have objected to that and noted it on the record, so they don't say, oh, okay, well, you accepted the arraignment, so you lose your right to a so-called speedy trial.
Speedy trial upon demand, except as otherwise provided by this rule and subject to the limitations imposed under subdivisions E and G. Every person charged with a crime by indictment or information shall have the right to demand a trial within 60 days by filing with the court a separate pleading entitled Demand for Speedy Trial and serving a copy on the prosecuting authority. No later than 5 days from the filing of a demand for speedy trial, the court shall hold a calendar call with notice to all parties for the express purposes of announcing an open court receipt of the demand and of setting the case for trial.
So that's different than you said, right, Cracker Jack? 60
Yeah, that's different. I guess that one's related to them filing.
Well, it does say
everything.
before that was B. A says speedy trial without demand. So there's speedy trial without demand and there's speedy trial upon demand. So I guess if you demand it and you take care of business right away, you got 60 days. But without demand, except as otherwise provided by this rule and subject to the limitations imposed under subdivisions C and F, every person charged with a crime shall be brought to trial within 90 days of arrest, brought to trial within 90 days of arrest if the crime charged is a misdemeanor, or within 175 days of arrest if the crime charged is a felony.
Yeah.
If trial is not commenced within these time periods, the defendant shall be entitled to the appropriate remedy as set forth in subdivision P. The time periods established by the subdivision shall commence when the person is taken into custody as defined under subdivision. A person charged with a crime is entitled to the benefits of this rule, whether the person is in custody, in jail, or a correctional institution of the state or political subdivision thereof, or is at liberty or on bail or recognized condition. Yeah, boy, that's a law that you can use to your advantage because they definitely don't do that for people, man. They drag people on. They'll keep people in jail for a year before they go to trial.
Right.
But what happens is that their attorneys, like this public defender, just waive all of that
Right. They
by
waive
not
it.
objecting to it.
Right. They waive it. Yeah, they waive the right. Come
So-
on.
So a regular trial has to be done in 190 days, was it, or 180 days? And a speedy
I
can be done in 60 days, according to Mike.
well, any trial is supposed to be a speedy trial. But what based on the Constitution, I guess some states have based on how serious the allegation is. I mean, they have different parameters by which they consider something speedy.
Right.
So that's what he's reading there. So that calls into consideration, the question of when the prosecution actually filed their affidavit to the court, or what is it that they call it? Yeah, they submitted the case or allegation to the court. And if it fits with and if they filed it in time. Let me look at the Constitution here.
So somebody can be arrested for a misdemeanor, I guess, obviously.
Yeah, yeah. Some misdemeanors, it's up to the discretion of the officer.
Okay.
Right. Yeah, that officer was just being an asshole. He didn't have to arrest you. He could have actually gave you like, guy, you're supposed to be here, go away, He was a prick.
Right.
You could sue his ass.
All right. So for example, this is amendment number 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have a compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense, which is where the public defender and stuff all comes in, as assistance of counsel. And then some of that stuff, where they'll say to be informed of the nature and cause of the accusations, and they'll say that that stuff's for trial, and to be confronted with the witnesses against them. They'll say that that stuff's for trial, but TV has made it all clear to us that that's not the case. You know, by all the depositions that we see are always done before a lot of these so-called popular cases.
So what are you suggesting?
Well, what I'm suggesting here first is to ask this public defender all these questions to show that if he doesn't think that you're innocent, if he doesn't want to believe that you're innocent, because as your attorney, whether you did it or not, he's to be fighting for you for your innocence. If he doesn't want to do that, then he needs to leave.
Yeah,
And
sounds like he doesn't want to hassle with all the extenuating circumstances like not wearing a mask and such.
yeah,
It's not working.
and then from there, he needs to show where the prosecution has provided that they have jurisdiction over you.
That again,
And he needs to show where the prosecution has already submitted to the court that they have a right to bring this case in front of the court, which is jurisdiction. And jurisdiction isn't based on where you are. It's not territorial, although in their legal sense they say if you committed something in Miami, okay, it's in the jurisdiction of Miami, they have jurisdiction over you. No, jurisdiction is actually when you do something wrong against someone and you've caused them harm or injury in some way, where they can recoup damages either by money or by returning something to them or having something fixed or whatever, in so-called common law.
so this letter by the state prosecution, I guess, doesn't show jurisdiction.
No, it doesn't show jurisdiction anywhere. It just says you violated a statute. And what they're going to say, you violated a Florida statute. You were in Florida. You're in the jurisdiction of Florida, the particular area of wherever that city was, and they have jurisdiction over you. And then they'll say, well, we have jurisdiction because the law says you have jurisdiction. How does the law show that I have jurisdiction, that they have jurisdiction over you? A piece of paper can't say that something applies to you. I know it's all abstract and it's hard to get one's thoughts wrapped around it, because that's not what we're taught, and that's not even what these guys even believe. But they can't ever prove that the piece of paper says that they have the right to make a claim over you. And they'll just keep going back and forth that, okay, or going in a circle. Well, we have jurisdiction because a piece of paper says that.
Right.
Oh, okay. Well, the piece of paper says that, and what would be the other logical, reasonable step? Or something like a piece of paper says that because you're in Florida. Well, because a piece of paper says that I'm in Florida. What's your reason for saying that just because I'm in Florida that this applies? And it goes back to the piece of paper and all that stuff, and you can't ever prove it. I don't know if what I'm saying makes much sense.
Well, I mean, if you try to challenge them, well, how do I know this? How do we know this paper means anything? Well, because this police officer wrote that paper. How do we know he wrote that paper? Okay, we're going to testify and ask him under oath. Did you write this paper, officer? Yes, I wrote that paper. Okay, so now we know that police officer wrote that paper. Okay, and see, that's where they start bringing in depth. That's why they have depositions to, which is essentially, that's part of what discovery is, because that's how they're establishing that they have jurisdiction by getting their witnesses. This woman testified that she said you shouldn't be there. She saw you there. This officer testifies that he arrived. He saw you there. She said you weren't supposed to be there. He said that you would trespass before. They just put it together, So in a way, that's all kind of playing the game, which I'm not into. It's not about playing the game. It's about, to me, it's about it's about the law. What gives you the right? What gives you the right to arrest me for trespassing? What is trespassing? What is trespassing? What's the spirit of trespassing? What's the intent of trespassing? When I look here, it says under chapter 810 of the Florida statutes, burglary and trespass. So there's clearly a spirit of the law there. In fact, if we read through all the law, what are we seeing? Firearms, weapons. If somebody's in the premise, they're looking at criminals with intent to do wrong. Where does it say in the law that a person shopping in a store can be trespassed? Where's that statute?
Well, it comes down again to the threat to public safety or welfare.
Right.
And
so now what threat? You're alleging a threat. So now I need you to prove the threat, because you can't just make an assumption. You can't just take my rights away from me and arrest me based on, just an ethereal assumption of a threat. So you're gonna have to prove the threat.
Yeah,
go ahead.
And that's like exactly what I'm saying too, because for them, the burglary part of that, I think is like inconsequential. It makes no difference, and that's just up for interpretation. It's just something that they put up there. But yeah, for them to actually say that they're going to arrest you for this, or say that you've committed this, you do have to complete some sort of harm or some sort of threat as what that statute specifically says in number 3, for them to even start imposing upon you. And if that's not the case, they shouldn't impose upon you.
So it almost seems like the first TAW, trespass arrest warning, I wonder if that even will play into the case, because does it even matter to them why the TAW was given to lead to the arrest, to the second incident? I mean, how do you fight the first one?
The TAW, based on this, would be issued because of this. First, they give you a warning.
Right, the trespass arrest warning.
Yeah, and then if the person so-called does the same thing again, then they say, okay, we're just going to make an allegation against you that you just violated this particular code.
So
there may
be
a section on a trespass warning, though, a TAW. There may be a subsection about that.
Right, because that's the main thing. That is the thing, really.
Okay, yeah, I see what you're saying.
I did have a TAW. I guess I'm not disputing that I was given a TAW, I guess, but that was an illegal TAW. So how do I fight that? Is that a separate thing that I'd have to fight, or I don't know.
If it were to go to trial, those are all elements that should be brought up at trial.
Well, of course, they'd have to be. That's
Yeah, but that guy is not going to bring that up.
it doesn't sound like it. Yeah, because it would, if that wasn't brought up, then the actual case for the trespassing has to be thrown out because we did not refuse to leave.
Correct.
And I've got that on video. So, yeah, I mean, it says willfully refused to depart after having been warned. We didn't refuse. I didn't refuse. So I don't get how they tie together. And
Well, they just make up things.
yeah, but it seems like they would. I mean, yeah, I guess it is a special thing with the mask, but it seems like trespassing probably happens every day with these cops and sheriffs, that they would have figured it out somehow. But I guess they get away with it so easily, they just keep doing it.
Yeah, that's their biggest. That's a big money making scheme for them. They arrest someone and they usher him into the court, and the public defender helps them to collect the money. You see it right there.
By putting the fear of God into him and arrest, fear of arrest and fear of handcuffs.
Right.
All that. Huh. Well, okay. I guess I'm gonna wait for Rick Martin. And if he doesn't, I mean, I'll see what he has to say, but if he doesn't help any, then I'll have to dig deeper.
Did you read over that motion to dismiss?
Yeah. You see, what was that?
It's for Alabama. I got that from Mark Stevens.
Right.
But you could put in the parts for Florida, and then tell that public defender that you want to contest all these allegations, and if you're presumed innocent before all this, you want them to go ahead and file that and submit the Brady material.
Here's the notice to dismiss, Mike, that Cracker Jack sent me from Alabama.
I think there are some like grammatical errors in there and stuff.
Yeah, probably.
That's what I was just reading here too. And
yeah, and I was going to, when I did mine, I had corrected it and stuff.
you didn't find that, Brian, online?
What notice to dismiss?
Well, maybe I'm looking at the wrong. I'm looking right now. Shows 2019 Florida statutes on my screen.
Oh. Okay, let's see what I gotta do here.
Did you send Cracker Jack what I wrote on your behalf that first night, just so you could read it?
I did. Pretty sure I sent it to you, Cracker Jack.
Oh, I just see that. I
Here's
haven't had the chance to like look through everything.
Here's the notice.
It's a little lengthy, but it's an overview of the reality of what occurred.
Here's the notice to dismiss. You seeing it now?
Mm.
Like, to me, it sounds like the prosecution doesn't want to deal with this. And if there's the slightest inkling of a fight, they're going to be like, forget about this.
Right.
And something like this notice to dismiss will give them the legal standing to say, well, okay, well, we're just gonna dismiss it. It's not worth it.
Yeah, because they have no case.
But I mean, yeah, I could just send them Mike's statement attached to this.
That's what you should do. Send that statement with that.
But when when would that get to the prosecution? I wonder. You know, if I,
It needs to get there before arraignment.
well, yeah, I mean, but do I send it to my public defender? Do I send? He may,
Oh,
sound like
because you have a public defender, unfortunately, everything has to go through him.
right. That's what I think.
You are not able to file anything directly with the court. And of course, whatever you file with the court, you have to send to the prosecution, or it's called ex parte communication. And that's,
Right.
grounds to
That's-
reprimand you.
That would show bias or something.
Yeah. But your attorney, he's not going to want to send that in, because if you look through that, right, it talks about the idea of corpus delicti, meaning that you've actually harmed someone, which in essence, that the statute 810 in subsection in number 3 alludes to in some fashion. And then I see the part about lack of jurisdiction,
Yeah, I saw that right there.
which is just, although I know you guys are focused on these laws and that they apply to us, unless you agree to something, law is a contract. And they think about it in theory, but when it comes down to actually recognizing it in reality, they don't. If you don't agree to the contract, the law doesn't apply.
That's Tom Barnett's big statement. He says a lot.
Right.
And it's just, bringing that up. Now, it doesn't mean that they won't railroad someone and they still won't usher in the case to trial or whatever. And they'll go there, and a lot of times they'll just say, oh, dismissed it. And then number 4, as you see there, is no presence within the state and the law's applicability, because the state of Florida and the state of Alabama per se is not the physical state. It's the so-called incorporation, which some people may want to call the sovereign citizen movement, which no one's a sovereign citizen. That doesn't make sense. To be sovereign and to be a citizen means that you're a slave to a group of people.
Right.
Right.
Well, yeah. So, I mean, that would just be a where they're mixing terms to say
Yeah.
sovereign citizen. No, you're a sovereign,
Mhm.
not a citizen, not a sovereign citizen. You're a
It's-
sovereign man.
Yeah, that's what I forgot which federal part. What do you call it? The federal section of the government that brought that term into regular use, just like there was that conspiracy theory thing that they brought to discredit people who were questioning certain things. They brought in the sovereign citizen claim to discredit people who were, arguing that all these laws and stuff are unjust and they're just harming people's lives.
Yeah, it gets a little tricky on that because some people are a little off. They don't really understand it, and they're a little off base with it all.
Yeah.
It seems that there's some real legitimate application to it all, but you really have to understand.
Steve could probably lay it out.
And that's what I was going to say. Steve, I think it kind of is contrary to what you were saying, I think, and that you were kind of, unless I misunderstood you, Cracker Jack, you were kind of distancing yourself from or disregarding the law, that the law is irrelevant or insignificant. Whereas, like what Steve would say is, no, if you actually know the law, the real law, the law actually kind of proves that you're a sovereign. It proves the real law proves that you cannot be if you take the actual law and say, no, here's what the actual law says, like they'll use example of taxes, it says taxes on businesses, for example, he'll say that the wording of the law makes it clear that taxes only apply to businesses. Taxes do not apply to the common person, to a human being, to a man. Doesn't apply. Right?
Hey,
Hey,
Cam,
Hey, what's up, guys?
how'd your practice go?
Man, better than we thought.
great.
And everybody was wearing masks, from what you were saying.
I took mine off because I couldn't sing.
He said one guy was freaked out, so he thought maybe.
Yeah, he wore it through the whole thing. Dumbass.
Wow, man.
He's a libtard.
Incredible.
So,
Yeah.
did anybody come on tonight?
Well, Cracker Jack's here.
Oh, he is? Okay.
Hey, again.
Hey, what's up, Crack?
All right.
We were just going over my case details, trying to figure out some stuff.
Yeah. Well, I was hoping we would have had some folk come in.
Yeah. We were hoping Leslie was going to be here, who was called Mike earlier today in a panic.
Did you get her email address?
Yeah, I sent it all to you.
Did you send her an invite?
Uh-huh.
Hmm.
But she was worried about was it her daughter or something? A kid going to school and having to wear a mask. And even though in her little city, they don't have a mask mandate, but they're trying to do it for the kids or something. That's stupid. Crazy.
But anyway, Cracker Jack, that's what Steve pretty much has a position of, that the actual law, it's because if you really know the law and you read it, you'll say, there's nothing in here that applies to me. Like he's claimed, and I've heard this from other sources, right? This is something that Brian and I have been wanting to really nail down. The notion that any mandate by a mayor or a governor, any mandate that's issued, any executive order, only applies to government agencies. It doesn't apply to human beings. It doesn't apply to the people.
In theory, sorry, go ahead.
Well, that's what he's saying, that if you actually read the law, that's how the law says it. Because anything talking about executive orders is only stating that it applies, it's only using it in context with government entities, agent. There's nothing specific saying it applies to me. But see, what they do is they play around with that, and they're like, well, yeah, it applies to government agencies because government agencies are the ones that are telling you what to do, right? But the actual law doesn't.
Which he hasn't got to you yet. The actual law. You were asking him to send you the.
Right, which I still haven't gotten from him.
Yeah.
He kind of quoted a few, but
Well, it seems like
give him a call real quick. Give him a call real quick, Brian, just to ask him that again.
it's a little too late. I'm ready to hit the site, but I was just gonna say, it seems like it all comes down to the direct threat thing on the TAW is really the linchpin of the whole thing. Because without that, I don't have the TAW, then I don't have the trespassing.
That's true. Yeah. So I see what Mike is saying is that instead of even waiting for it to get to trial, to then argue the specifics of the case, of the statute, what I'm talking about is not waiting for a trial and not calling it a trial issue, and then questioning them and making them show just cause for even bringing whatever allegation even to trial, so it doesn't get that far. Now, that will avoid a person from setting any legal precedent about whatever allegation they're making and trying to get it overridden.
Would that be consistent? What you're saying consistent with our contention that, essentially, to rephrase what you're saying, is this what you're saying? jurisdiction? What's your jurisdiction? In other words, what application of the law? What is your legal basis for being able to trespass somebody for being in a grocery store?
Yeah. That-
Where's your legal basis for that?
And they have no legal basis.
Right.
When they examine the statute, they have no legal basis. And then even in terms of that entire statute, they still have no legal basis. Because you never agreed to be bound by that statute.
Right.
And so they shouldn't be bringing that, against you.
So I haven't agreed to the contract, you're saying?
Yeah, you haven't agreed to the contract. But they just assume that you've agreed to the contract. And that's why the Aussie guy wants to say, oh, wait for, after arraignment. Because if you plead not guilty, I mean, that's saying that you agree to their contract, to their claim. And so you want to go to court asking if you've broken the contract, to determine if you've broken the contract. That's the position that I'm approaching this from. There is no contract because you've never agreed to the contract. And if enough people did that, I mean, they'd stop all the allegations of saying that people have violated any contract.
So you're saying the thing to do is go there and say, have I broken any contracts?
Essentially, that's what questioning jurisdiction is. That's essentially what it is. That element of jurisdiction, that entire motion to dismiss, there are how many different parts of that? The jurisdictional element, the corpus delicti element, the so-called existence within their claimed state of portion. That's all trying to see if they can show just cause that you've broken each of those particular elements of the contract that says that you're bound to that particular statute, 810.
So let's go back to your initial point that maybe wasn't fully understood by Brian Orme when you said to plead guilty, which seemed kind of freaky. It's not that you're really saying to plead guilty. You're just saying, essentially, hey, I mean, I'll plead guilty if you can show me I'm guilty.
Exactly. Oh no, you're not trying to say that you're going to plead guilty, because
I like that actually. I really like that, Craig. Hey, I'll plead guilty if you can show me that I'm guilty. If you can prove to me that I'm guilty, I'd like to discover. I'd like everything you have that shows I'm guilty. Because if you can provide me with that, I'll go ahead and plead guilty.
Mm-hmm. That's a different way of placing it. If you can show that you're guilty, but then they'll say, oh, that's a trial thing. What the wording to use in place of it is, if you can show that you have a right to make this claim against me.
No, you say tell me if I've broken any laws. What laws have I broken?
No, I think Cracker Jack, you tuned in just a wee bit too late, Kenny, to get it. Because I was just catching where you're coming from, Cracker Jack. Say it again the way you said. Show me that you have the right.
You have the right, not to say that I'm guilty, but that you have the right to actually bring the claim against me. That I've agreed to this particular to be contracted. I hate to use that particular term because it's used so regularly in the
There's got to be another way to term it then. That show me that you have the right to bring. See, there's a play between the word contract and charge. Show me you have the right to charge me. Show me the right to
show that you have the right to actually charge someone with this, and that charge someone with it has a lot of meaning.
Well, and that does go to what Kenny said. So forgive me, Kenny. Maybe you're right. Again, isn't it therefore then? Show me the law that I violated. But even
Yeah,
if you
what
do that, then you're agreeing.
Did I break the law? What law did I break?
And of course, they're going to say trespassing. You trespass. So
Yeah,
you
but
broke
you
the law.
can't call somebody for trespassing if they haven't done anything wrong. So it's going to hinge back to the mask. Got to.
Right, which is actually plays into our hand, Brian, because that goes before you came on earlier, Kenny. We were talking about the one good thing about this. If if it were to go to trial, which I don't see it going to trial anyway, it's going to get thrown out. But if we were to go to trial, we have the right to deposition witnesses. And how great would that be to have that woman come in and have her under oath, and we'd have a slew of great questions for her, about. Is your store subject to federal laws? Is your store considered a place of public accommodation? There's just all kinds. Do you have the right to discriminate against somebody for not wearing a mask? There's just all kinds of beautiful questions that would be asked of her that she'd have to answer. She'd be so fucking tongue-tied and not even know how to answer the questions.
Even the cop wouldn't know how to answer anything.
Right.
So if we,
because a cop to have arrested someone for that has to show that they've made a legal determination that the person's broken the law.
Right.
But a cop can't say he's made a legal determination because he's legally indigent. He doesn't know the law. All he can say is that he's made an observation. But that observation, they euphemistically also lump into, he has a legal right to arrest someone for it when he doesn't.
Right.
well, again, if the TAW is valid, and then I step back into that building, then I can see being trespassed. Because
Wait
that's
a
all,
minute.
that's all
Wait,
the
the TAW was the first one or the second one?
yeah, it's the first one, the trespass arrest warning, TAW.
What is the statute for that?
I don't know. I haven't.
I was looking for it. I couldn't find it.
And that's one of
In
those
fact, I don't
things
even see a statute for that.
and that's one of
which
those
could be an
things that
interesting
guy, has to, the attorney should have explained.
well, here's something that I just, I don't know if you can see it, but just from the Advocate for You, trespass after warning, they call it here, is not as simple as it sounds. Yes, doesn't really, they're talking.
Now, this is significant, though. It says law enforcement officers may have the authority to arrest any individual who, after being lawfully warned, refuses to leave the property.
Okay,
And that was not the case the first time
there's two things.
that you left.
There was no, we didn't break a law and we didn't refuse to leave. So both of those are invalid.
Right. Any written trespass warning issued by law enforcement shall be included in or attached to the incident report.
Which I haven't seen any. Well, maybe I did see it. Let's see.
Officer sued for issuing man trespass warning. March 16, 2020. We should look into that.
Where was that, in Florida?
Let me go back to that in a second here.
That's
Trespass
interesting.
warning. Yeah.
And if more people did that, and all these cops had suits against them, instead of things that were taken care of by the state, they would stop doing a lot of crazy stuff.
Okay, here's the first.
Wait, here's something that says it's Valencia policy, responsible official, vice president, business operations and finance, policy contacts, managing director, safety and security. Boy, this is like right from the corporate freaking structure of the state. Specific authority, 101.64 Florida statute. Let's look that up. 1001.64. 1001.64 FS.
Now look, if they drop it, Brian, just say, look, can I get that $350?
Yeah, you should get all of that back.
No, I mean, he never paid it, but I'm just saying, just say it to him. Say, look, I want to get that
Oh.
350 you were talking about.
You know, if they dismiss a case, yeah, a person can actually ask for money for all the damages and time wasted and stuff. Doesn't mean you're going to get it, but
Okay,
Sure could use that 350, you know.
right. If Ozzy, you could give that to me for your incompetence, please, sir.
Officer sued for issuing man trespass warning and telling him to leave premises. On July 19th, 2019, the 11th Circuit Court of Appeals decided Watkins versus Miller, in which the court examined whether, in response to a 911 call regarding a man in a parking lot, an officer violated the 4th or 14th Amendment when he stopped the man, issued him a criminal trespass warning, and threatened to arrest him if he did not leave the private parking lot. The relevant facts of the Watkins directly from the case are as follows. And it's got a whole lengthy written thing.
Here's what they gave me on the 5th for the TAW Cracker Jack. It just says same male back in store with no mask, because I was in there a couple days before. Refuses to wear mask and refuses to leave. Coming up towards register now. TAW issued, Brian Root. That's all they have on this, whatever this is called. So
See, this really does come down to, like Cracker Jack saying, jurisdiction. On what basis, right? What's your basis? What's your basis for trespassing me to begin with?
I know it's all abstract. I'm not doing a very good job of explaining it. And when I came across this, yeah, I was always wondering, what is it that you're asking for them to prove? But it's really the applicability, the law's application to you. Does the law apply? Does
Right.
their claim apply?
It
And
doesn't
it
apply.
doesn't.
It doesn't apply because they have to have a vote and they have to.
No, not even all of that. You have to agree to the law.
Yeah.
The law is a contract. We all just accept it because, oh, it's written down in some book in some big house. Now all of
Right.
us can look at it on the internet, but we never agreed to it. The only thing we agree to as living human beings is, if I hurt you, you have the right, the justification to seek remedy for it. If I take something from you, then I've actually damaged you. You have the opportunity then to seek jurisprudence over me, or in other words, jurisdiction. You've got that. They don't have that, and that's where you were referring to, where the guy was saying, if you know the law, if you know the particular statutes and codes, you can use it against them. And yeah, you really can. But why even take it that far sometimes? Because sometimes you may have, a terrible judge that's going to prevent you from bringing up certain arguments that would be to your benefit.
Right.
And then you just have to, take that up on appeal or something like that.
Right. That's the problem with this legal system. They can fuck with you,
Mm-hmm.
Kenny froze right in the middle of taking his pants off. That's pretty cool. Where'd you go, Ken? I think I'm gonna hit the sack here, fellers. And we'll continue this later. Ken, your
Guys ready to close it up?
your BG lagged out tonight.
No, I was in the bathroom.
You froze up while you were taking your pants off. We got to see you with your pants down for about 5 minutes.
I wasn't looking at the screen.
Thank goodness. You didn't want to see it. No, just kidding. It was taking off some. Yeah, Ken, I'm gonna head out. I don't know if everybody else is.
Guys, well, I guess I'll.
All
Good night, you
right.
guys. Good night, Cracker Jack. Good
Yep.
night,
All
bro.
right. You guys have a good night.
Cracker
All
Jack.
right. Bye-bye.
See you guys. All right. Good
All
night.
right. Bye-bye.